right, so today we're going to finish up deeds of trust and closing the deal. These are the last topics that we need to cover before test 3. So a deed of trust is what we have in Virginia. It's a 3-party instrument, and legal title is vested in a trustee. And so when it's allowed by state law, lenders prefer deeds of trust because you can do a non-judicial foreclosure. They're faster, they're easier to recover your money. So a note and a deed of trust are prepared by the lender, and deeds of trust are always recorded. So I just wanted to show you, this is the Virginia statute, and this is what a deed of trust would need to look like in Virginia. So as I said before, the deed of trust gives the lender the right to accelerate the loan. And it also gives the lender the right to exercise a non-judicial foreclosure. So after default, what happens is that the property is sold under the power of sale that's granted by the deed of trust to the trustees. And after default, the proceeds are applied in terms of paying the debt with interest, and if there's any remaining money, it is returned to the debtor. Again, a couple of things bolded on these slides. These are things you need to remember for the test, and that is that when allowed by state statute, a lender would prefer a deed of trust. Late charges. By statute, late charges may not exceed 5%. They may not be collected unless the payment is at least 7 days late. Most lenders allow 15 days. And a late payment generally does not affect your credit score unless it's 30 days late. Some other charges associated with financing a real estate transaction, you may see the term a point. A point is simply 1% of the loan. There can be loan origination fees. They're allowed by statute in Virginia. There are also fees associated with the title examination, title insurance, recording fees, taxes, insurance, appraisals, credit reports, document preparation, inspection, attorney or settlement agent's fees. So lots of fees associated with closing the deal and actually obtaining financing for a house. There's some specifically targeted government loans just that you should be aware of that they exist. The VA loan program was created with the GI Bill passed at the time of World War II. FHA, the Federal Housing Authority, was established in 1934 in the Great Depression to stimulate the housing market. And then, of course, we have the Farmers Home Administration loans. Those are specifically targeted. Although you do not have to be a farmer to obtain one of these loans, they are only granted in rural areas. Let me just point out one thing that you may see, due on alienation clause. In other words, if you see this clause in a loan, then the loan is not assumable. So this is not a big deal right now because interest rates are so low, but in the late 1970s, early 1980s, when interest rates skyrocketed, it was very important for a purchaser to be able to assume the seller's loan. It was really difficult to get any real estate transactions to close at all at that time because interest rates for mortgages had gone up to 17.5%. Some other loans, let me just mention some other loans. So a conventional loan would be a non-government loan, and in Virginia we have the Virginia Housing Development Authority. And I wanted to point this out because it was created in 1972 with the express purpose of making it easier or more affordable for low and moderate income Virginians to purchase a home. This program, the VHDA program, again is targeted at low and moderate income Virginians, and it is self-supporting. So funds are raised through VHDA bonds to support this program. Let me just point out a HELOC or a credit line deed of trust. This is essentially a second mortgage, but HELOC stands for Home Equity Line of Credit. Prepayment penalties. In Virginia, the prepayment penalty on a deed of trust loan is limited to 2%. And here's the statute. What I wanted to point out to you is this. I suggest that if you purchase a house that you don't go longer than 15 years. But if you do, say you absolutely cannot afford anything but a 30-year, I would negotiate with your lender so that if you are in a position so you can prepay the loan, that there's not a penalty for prepaying it. So this is a negotiable term. You could get rid of this in your lending documents. Foreclosure. Now, a foreclosure is what happens when there's a default by the borrower. Usually the default occurs when payments aren't made in a timely fashion. But you know, you could have a default in another way too. So other breaches of contract could cause a default. So if you didn't pay the mortgage on the, didn't pay the insurance on the house, or you didn't pay taxes, or you commit waste, these all could bring on a foreclosure proceeding. All right, so let's apply the law together. So the first question you had in your booklet is, which of the following is true of a loan sold outside of Virginia? And the answer is the loan must be notarized with a seal. All right, so your second question, the maximum late charge that may be charged on a mortgage loan is 5%. The third question, a deed of trust that permits the borrower to receive advances from time to time up to a maximum amount is called a credit line deed of trust, or a HELOC, home equity line of credit. 4, on a first deed of trust where the rate is stated in the loan agreement, what is the maximum interest rate allowed by law? Well, a little bit of a trick question. There is no limit. 5, Jack and Jill have a combined income of $175,000 and they would like to buy a condo at Wintergreen. They intend to use financing through the VHDA, that program intended, especially targeted for low and moderate income Virginians. What will be the probable outcome of their application? Well, they make too much to qualify for a VHDA loan. And then the last question, in writing a contract or purchase and sale, a real estate licensee should ensure that if a first lien deed of trust is obtained that, and your answer is all the above, that the contract is contingent upon the purchaser obtaining a loan, that the contract provide a ceiling on the interest rate, and that the contract states the type of financing to be used. All right, so let's move on. Last topic of test 3, and that is closing the deal. So in terms of closing the deal, it varies from state to state. Today we're going to look at some different things. We'll look at how is a closing done, what documents are necessary, who are the parties, and what are their responsibilities. All right, so under CRESPA, the buyer has the right to choose a settlement agent. And in Virginia, the settlement agent does not have to be an attorney. However, the settlement agent would have to be registered with the Virginia State Bar. So a settlement agent collects the documents, disperses funds, and records the documents. As I said, usually it's an attorney, or it could be a title company as well. And in Virginia, all settlement agents would have to be registered with the Virginia State Bar. They must carry malpractice insurance, and they must maintain a surety bond as well. If a settlement agent oftentimes runs a lot of money through their accounts, but no interest may be earned on funds that are held in escrow as a settlement agent. So here are some closing services that could be available. Title insurance, receiving funds, receiving and dispersing funds, surveys, inspections, settlement statements, documents prepared, recording those documents, and of course recording the sale to the IRS. These are things that the settlement agent may very well be involved in. Escrow instructions include who's to pay what costs. How are you going to allocate costs? If you look at page 422 of your book, you'll see how costs may be allocated. And there are a couple different methods for determining proration of prepaids. So proration of prepaids ensures fairness in expense allocation. So the buyer pays for coverage from the time of closing. There are two formulas, and those two formulas are on page 423. You don't have to know either of these formulas for prorating prepaids. And of course, in the escrow instructions, there'll be a bill of sale for any personal property that's being conveyed. So here's some of the documents that are to be delivered at closing. The seller's going to deposit the deed for transfer, and additional documentation could be the title abstract, opinion, title insurance, is there a tax bill, insurance policies, warranties on appliances, heat pumps, property condition reports, keys, return of earnest money. There could be either a mortgage or a deed of trust, and certainly a note, and a truth in lending statement, and a RESPA settlement statement. So at closing, you have a mountain of papers. Now, I participated in closings at lots of different locations, and they were handled in different ways. I have participated in a closing that was all done by mail. I participated in a closing at an attorney's office where it's a very formal procedure. I participated in a closing where the lender, actually it was Quicken Loans, came to my house to do the closing and to deliver papers. So lots of different ways to have closings, some more formal than others, but at a closing I guarantee you will be overwhelmed with the number of documents that you will receive. Allen versus Martin was a case in your book, and there was a conflict in this case between the escrow instructions and what the real estate contract actually said. So here are the facts. Martins wanted to sell their house so they could complete and then move into their mountain home. They entered into what was a time is of the essence contract. In other words, the closing date is the closing date. And it was a contract to sell to Mr. and Mrs. Allen. Closing was to take place on July 3rd, 1972. A 15-day extension was granted, but there was never a closing. So the Martins signed a 13-day letter as per the escrow agreement, and if you look at the escrow agreement, it's on page 425 in the book, and the Allens complied with the 13-day demand, and the Martins then refused to sell. The courts rescinded the contract, and they awarded $1,000 to the Martins. And so what this deals with is that the contract itself governs, not the escrow instructions, and this was a time is of the essence contract. So here's some responsibilities of the lender. RESPA applies to all federally related residential mortgage loans. It does not apply to commercial transactions, and it does not apply to home loan refinancing and home equity lines of credit. But here's what you have to know. You need to know, what was the purpose of this statute? So the purpose of the statute primarily was to eliminate surprise fees that were encountered by buyers. It was also to eliminate kickback or referral fees to these closing agents. And it reduced the amount that buyers are required to pay into escrow for taxes and insurance purposes as well. So according to RESPA, a lender must provide a good faith estimate of settlement costs. So within 3 days of a loan application, the lender must give the borrower an information handbook, and it's created by HUD, and it includes a good faith estimate of closing charges. Even with the good faith estimate, I have to tell you, you're always surprised by how much the closing charges add up to. Advanced disclosure of closing costs is required. And anyway, so again, you'll probably be surprised at the closing costs, even though you must be given a good faith estimate ahead of time. Kickback and unearned fees, I will tell you that prior to this law, it was not uncommon for escrow agents to pay a kickback fee to the lender or to the broker for a referral. This is now expressly forbidden by RESPA. RESPA also prohibits sellers from requiring that buyers use a certain title company. The covenant abstract case we're not going to go over, but this was an ethical issue where kickbacks were paid. And again, that is one of the things that RESPA did was specifically prohibit sellers from requiring that buyers use a certain title insurance company or that kickbacks be paid to lenders or brokers. RESPA limitations on escrow deposits. One of the purposes of RESPA was to eliminate excessive prepaids. Lenders want prepaid taxes. They want prepaid insurance to protect their interest. All right, so again, I told you that there are two methods of determining how you're going to prorate taxes. And so here's an example. Annual taxes are $1,200 and they're due on April the 30th. Closing will occur on July the 15th and the first mortgage payment will be on September the 1st. Under RESPA, the maximum deposit would be $600. And so the way that's determined is $100 for May, June, July, and August, plus a 2-month cushion. If you want to, you could consider 16.5, and we are going to apply the law together. And so the first question was, according to RESPA, the selection of a settlement agent is made by the buyer. And then, which of the following did RESPA do? And your choices are prohibited sellers from requiring that buyers use a certain title insurance company. Yes. Prohibited referral fees paid by settlement agents. Yes again. Prohibited, provided good faith estimates of closing costs given to buyer prior to settlement, and the answer is yes. So RESPA did all of the above. And then, which of the following is not true? And of these items on this list, lay settlement agents are not, so this is not true, are not allowed to advise buyers on how to take title to property. The other items here are true. And then true, false. A settlement agent may earn interest on any funds deposited in connection with settlement, closing, or escrow, and the answer is false. All right, so next class, you will do a review for the test. There is a pre-recorded review that's posted on YouTube that'll be available. I hope you have a good rest of your week, and take care.